Everyone. Today we're here with Sara Dickson. Sara, why don't you go ahead and introduce yourself?
Great. My name is Sara Dickson, and I have been a therapist since 2006, 2009. And I've also been a mediator for a Utah court roster appointed mediator for the state of Utah since 2016. And that's my background. I've also worked with the juvenile justice system, working with juvenile offenders, helping them lower recidivism with teaching skills. So that's just kind of my educational background.
Thank you so much for being here. And I know today we're talking more about mediation. So for people who are watching and don't know what divorce or child custody mediation during the lawsuit or after the decree has been entered is, or have just been ordered to participate in mediation and don't know what it is, what is mediation and what is it used for? Would you give us a brief explanation?
Absolutely. Mediation is used to help parties try to reach a compromise between them or a settlement in their case. And so it's just a way for the parties to participate in a negotiation process. The mediator is the neutral third party. They don't take sides. They don't advocate for parties. That would be the attorney's role if attorney was present in the mediation. It's basically just a meeting where the parties get to advocate for what they believe would serve the best of their situation, whether it's a child custody, whether it's a financial settlement, or a modification to a current decree that they have had ordered by the courts. It's a way to come in and look at how can we basically go forward in our relationship, and or separate assets, debts, and also figure out what child custody. So it's really just a meeting for them to go through the negotiation process.
I was ordered to go to mediation and I've never been before. What should I expect? What would happen?
That's an excellent question. So mediation is definitely ordered in the majority of cases, even business cases, to attend so that the parties can try and reach a resolution prior to going to litigation, going to trial, going in front of a judge, and going through the emotional and financial cost of litigation. So it's a way to meet prior to that to try and, basically put out all. So the really what you're expecting in mediation is to come that day. It's typically an all-day meeting where you start whether in the morning or early morning hours, and it can go all the way into the evening. The longest mediation I've ever participated in was 13 hours. So I've definitely been in a very intense all-day mediation. So you can expect maybe being there for a couple of hours. Most courts or judges or commissioners will order a minimum of a 2-hour mediation. So that's a pretty typical time frame to at least expect a few hours within the mediation process. You go into a room. If there's attorneys present, you're going to be separated into two different rooms. So that you can have really time to meet with your counsel, with an attorney, be able to talk freely with your counsel so that they can give and advocate for your specific case. And then the mediator, which I am, goes back and forth and they shuttle between the two rooms and they're able to talk, making sure they're hearing both sides of the parties. And so expect to have some downtime in between. And so expecting just to have maybe some snacks present, a water, a book if you need to, your laptop if you want to do some work in between or emailing in between, because the mediator will shuttle between the two rooms. So there may be some times, 20, 30 minutes, where you're going to have some downtime or to discuss with your attorney. So that's kind of what to expect. You can bring a support person to the mediation, so you could have someone that can support the process, whether it's a family member or a friend that can also be there with you to support. That's a pretty typical, I would say, what to expect in mediation.
A lot of people, when they're doing something new for the first time and they're ordered by the court, get a little nervous at mediation. So how do you handle situations in which people are nervous at mediations or who break down during the mediation?
That's a great question. So the majority of people, when they are ordered to mediation or they find themselves in a situation where mediation is really needed, it's not like they had ever expected to be in that type of situation, to be negotiating on what they are really wanting for a settlement. And so automatically emotions are high, anxieties are high. That's very common. Understandable. It's something new. You're trying something new. And so part of my role, and again, the background of being a therapist is very helpful in that I always want to make sure my parties are heard and they're seen. So they're able to have a moment just to share their perspective, where they're coming from, kind of have an opportunity to express what their desires are for settlement, what they really feel serves the best interests of them, or the parties that they're talking about, mainly their children. And so I really take an opportunity to build a rapport with the client so they can get to know me. They can know we're here to try and resolve the matters. It really is, that's the goal of the day, is to help them try to resolve their matters and come to an agreement so that they can move on in their relationship with the party, especially if they have children, they're going to need to co-parent together. So beyond the mediation, I try to help them see this is just one day, one setting. You're going to have to work with this person. So let's really try to help you guys design a system that's going to work. And so I try to help them see beyond the day so they don't get so fixated in the moment, get stuck in that space where they're like, this is hopeless. We're never going to get anywhere, and try to see, okay, I get that. Let's try and think of some brainstorming ideas and let's come up. So I'm very solution oriented. That seems to be a really positive approach with the clients that I've worked with, is helping them see, you're right, this does feel like a stock point. Is there anything that we can think of? And I come up with ideas that I've seen. I mean, I've mediated hundreds upon hundreds of hours. I couldn't tell you the number. There's hundreds of cases at this point. And so I have lots of ideas that have worked with other parties. I understand the laws, so I can provide lots of different ideas to help.
Yeah, I mean, people going through divorce mediation or child custody mediation, they're not in the most level emotional spot. So that probably really helps that you have a therapy background to help them, because emotions run high in divorce and custody cases. People are in situations they never thought they'd be in, and they're afraid of losing time with their kids or losing their home. So they get very, very emotional. So I bet that helps a lot, calm their nerves and let them focus on the real issues at hand and try to get to an agreement.
Absolutely.
So I was looking at your website, of course, before I was talking to you, and I saw you offer different types of mediations. So what type of mediations do you offer?
Well, the main part about it is I work with attorneys. And so that's a pretty common, I would say the most common form of mediation that parties know. They have an attorney, they've been ordered to mediation, or the attorney has suggested we should try mediation. So that's a very common type, where you have an attorney, you're represented by counsel. And so you have an advocate for the law. They're going to give you direction on what they think will be the best for your case, and also some ideas for settlement as well during the mediation. So that's one type of mediation where you're represented. Another type of mediation is called pro se. So your pro se litigant means you're representing yourself. In the state of Utah, and in a lot of states, you can represent yourself at any point. If you choose to say, you know what, I'm just going to advocate for myself, represent myself. And so I have an extensive working experience actually with pro se litigants, parties that feel like they're amicable enough where they don't need attorneys to talk for them, to advocate for them. They feel like they can advocate for themselves, or they want to work with their potential co-parent, or even if they don't have children together, they feel like they can work with their spouse to reach a financial settlement together without having to involve attorneys. And with that type of mediation, I typically meet with them together, which is unusual. Most attorneys are like, what? That's very unusual because it's different. But I find that the majority of my cases are actually pro se litigants. I've, by word of mouth, and just by people finding my website, understand that I actually do different types of mediation. So I can absolutely meet with them, without having to have an attorney. What I do in that role, the only I do it in both settings, is I really definitely go to all the trainings and understand the latest laws and statutes for, the domestic laws that we have. So we bring up the state statutes. So we bring them up. I have like a big laptop in my room so people can read the laws and understand what they're entering into, so they can understand the difference even just between physical custody, joint or sole physical custody, as well as joint or sole legal custody. And there's actually two different types. So I do a lot of education just using the laws and helping them to see that. So that's just the two different types of mediation, as well as I not only work with a lot of domestic cases, meaning divorce, child custody, modifications to an original decree, but I also work in business. I've done real estate mediation. And so a lot of times in those cases, I've done a dog breeding contract mediation. So really in the last 7 years, I've done quite a few interesting mediations, and most of those were also, there's no counsel and they're just representing themselves. And so I can also do a shuttle mediation in that as well, if needed.
Has there ever been a time with a pro se litigant that you've suggested to them to hire counsel, as like one party knows more about law than the other party and is trying to convince someone to enter into a bad agreement? Have you ever had a situation like that with pro se litigants?
That's a really good question. I have not, because when you ask the question, have I recommended they go seek counsel? There are some times where they want to start pro se, and then through the process they're finding, you know what, I think we need to go a different direction and hire counsel, which I absolutely recommend. If that is if they don't feel like they're getting anywhere, if they don't feel like it's fair enough to them, that's absolutely a great avenue to go. I have lots of attorneys that I recommend. There's so many great attorneys. We have so many wonderful attorneys in the state of Utah. I'm really there's so many great firms you can go to. So that's definitely happened. I always have a couple of cases a year where we start trying to sort through things and they realize that negotiation just breaks down. They want to go the route of the attorney. So absolutely, I suggest that's the best. I do inform them as well when they're starting with attorneys, they will also attend mediation, most likely with their attorney. So it's great. So then they've already had experience with a mediator. And a lot of times, sometimes I'll even been hired again when they have counsel, because I have some knowledge of the case prior. If there's a case where you ask the question, if it feels like unfair, or if someone, that's not my role. My role as the mediator is to allow them to make the choice. So I provide them with all the laws and statutes and the information and the education. And they, as an adult, and there has been a few cases where I have worked with someone that American Disabilities Act, so ADA, and I make sure that they have proper support to help them in the mediation. A sibling, a friend, a parent to be with them so that they can maybe explain a few things. But for the most part, the parties they're representing themselves and they're advocating for what their settlement is and if they're two, adults making a decision for themselves, that I'm not going to hinder that process, because that is what they have agreed upon and that's what they feel is fair. Obviously, I will inform them to make sure that they are agreeing upon all the things that the judge will need them to agree upon in order, specifically in the divorce setting, that the judge will need them to agree upon in order to settle their case completely.
Other questions about pro se litigants, but you've already answered them all. So I wanted to know, what can people do to come to a mutually satisfactory settlement when they're all together with you? Yeah,
so there's some ground rules. If I'm meeting with them all together in the room, there's some ground rules that I provide so there's always going to be a document, or there should always be a document prior to starting mediation. Basically, it's an agreement to mediate. And so the parties are understanding what mediation is, what's the process, what are their rights in that, what are all the different, in good faith, confidentiality. So the mediator should be explaining all of those things prior to starting mediation, as well as the fee structure, their hourly rate, all of those things that should be explained prior to starting mediation. And in that, I have ground rules where I'm meeting with parties. If they're sitting on my couch right here, I need them to be able to not interrupt. So talk, one at a time, so I can make sure that every party is heard in the negotiation process. They need to be respectful and courteous of the other person in the room and their perceptions and feelings. And I ask them to leave the past in the past and focus on ways to improving their relationship in the future. So those are the ground rules that I have them, understand that that's what we do. I also have a boundary that we're not going to get into a place where we're yelling at each other. If we need to take a break, that is absolutely okay. We've taken breaks. I've said, okay, we're going to take a recess for like 30 minutes. Go ahead, go get some food. I stop my time. So I'm not, charging during that time, but sometimes they need a moment. I'm like, go ahead. I have a great neighborhood. There's a park down the street. Go ahead, take a walk, take a drive, go grab, like a soda from Maverick or whatever. Not sponsoring them, but I have one just down the street. I might go grab a drink, soda, just something to get some caffeine in you, and let's then reset back. So that's my one boundary when we're meeting together is number one, that we don't have any yelling, because that's unproductive. You're just a breakdown. And also no transference on me as the mediator. I didn't cause the problem. I'm here to help. So that is, I'm very clear on my boundaries, is that I'm not part of the problem. I'm part of the solution. I'm here to try to help negotiate and resolve your situation today.
What kinds of things have people done to prevent settlement or sabotage negotiations? Have you ever seen that happen?
Yes. Yes, it's quite common. Number one, I think a lot of people get in their own way and they feel like I have to have this. And in every case that I've ever worked on, I can find it within the first about 10 to 15 minutes, or even 5 to 15 minutes. They have something that is so important to them. It's been labeled like a pain point, or it's something that is like so important to them, kind of like their main goal and value. I like to figure that out. And so I will ask a lot of questions to help understand what are the priorities for each party. So I try to, it's that knowing that how, mediations can just break down and not, I try to start there so that I'm already addressing it, so that I can understand for this person, this is one of the most important things that hopefully, even if we don't settle everything, we can come out today knowing that we've addressed it or talked about this specific topic. And even better, if they've reached a resolution with the other party on it. So that's something that I'm doing. I know that doesn't necessarily answer the question, but I do find that people get in their own way where they want everything to go their way. That would be probably the main thing, that they think, well, this is what I want, so the other person has to agree to it, because it's logical. And that's because it's their belief system. And I get that, but there's a lot of emotion behind that. So if they can come to mediation with an era of, okay, there's a couple things that are super important to me that I want to make sure we address, but also come in with an idea of, we're going to need to make an agreement. So there's going to be some give. We're going to find our way to the middle. Somewhere in the middle, there may be times where you're a little bit more one-sided to one party. Maybe they'll come to your side, but it's about in the air and the spirit of trying to come in, instead of saying, well, it's my way. I have to have everything my way. I would find that would be the most determining factor if a mediation is just not going to resolve itself and need to go to different litigation, pretrial, and things like that.
That happens a lot. People are like, it has to be my way. It's like, no, it doesn't. But there's a lot of emotion behind that. So
absolutely. And I completely understand that. We're talking about finances. That's hard to talk about. Normally, you don't talk about that with anyone under the sun. Yeah, you're mainly just talking about it with your partner, your spouse. And then you're talking about kids, your children. That is incredibly difficult to talk about. And I'm also, some of my background that does help is I'm a child of divorce. And so I've actually lived and I've lived that my whole life since the age of 6. And so that gives me a lot of knowledge into different transitions in between the homes. So I have a lot of knowledge that I can help provide in that space to help them see, like, your kid's going to be okay. I've turned out great. Divorce is not going to destroy the person. What will is conflict post. So I try to help educate them in just some background. It's a transition for the family. The family was in one home, now they're in two. That's a transition. But what destroys the children and where they have long-term, damage from divorce is the conflict level between their parents. If the conflict remains high, and you can look up all these Harvard study from Columbia, all the different conflict studies that are out there, they all talk about when conflict is high, the children are in survival mode and they will not thrive post a transition in the family. When conflict is low, whether they're married or divorced, the kids will thrive and they'll be able to launch themselves into adulthood. So,
Do you ever have to talk people down as using children as kind of a weapon of, trying to take them away from another parent? Have you ever had situations like that where they feel like the only way the kids can be successful, the kids can be successful, is it's only one parent has all the children, even if the other parent is a completely capable parent?
I would say early on in my mediation practice, a lot of parties were still under the assumption that one parent gets the majority of the custody. Since the evolution of joint physical custody specifically with children, I think people are a lot more open and they're seeing it a lot more, whether they're seeing it with neighbors, friends, family members, that a majority of cases are doing a joint physical custody in some way, anywhere from a 70-30 split all the way to a 50-50 split of time between the co-parents. And the judges and commissioners as well are very supportive, as well as custody evaluators, we really do want to give opportunity for both parents to have time with their child. And what that looks like will be a negotiation between the parties to say, well, what can we do? But there is some cases where parties definitely do feel like, well, I've taken on that role. That has been my majority role in this partnership that I've had with my co-parent, that I've had the children. And, that absolutely, I can understand the feelings behind that, because that is the role that they've been playing. But as they transition into a divorced situation where there is two homes, the need for both parties to provide income is pretty high. Unfortunately, we live in a beautiful state, but in a very expensive state to live in. And so both parties are going to need to provide some sort of income for themselves, even if it's one where there's a spousal support, where they're getting an education. But the reason behind that is to help them launch into a career that they can have and support their household. And so with that, having the option to have a little bit more of a shared custody and parent time will allow for more parents to have some dedicated work time, as well as dedicated time to be a parent. So it's important to kind of help them brainstorm into different ideas, and also to give an opportunity that either way, even if you're doing a sole custody, one parent will at least get a maximum of 110 overnights. So there's always going to be a division of time. And so that kind of, I've seen that.
Some people, when they go to mediations, they feel like the mediator has a lot of power over the situation. Like anything they say is law. So people who don't know, how much power do you have over the parties at mediation?
I am not in a power role at all. That's definitely, as a mediator, that is not my position. Really, I really try to stress that it's the parties that are advocating for themselves. And if they have counsel, listen to your counsel. That's the person you hired to help advocate and help you really resolve brainstorm your case. And so as the mediator, the only thing that I have power over is just me going back and forth between the rooms with that. But I'm not in a power role at all. I'm not making any decisions for the case. The parties are the ones making the decision. I am just communicating in between both rooms and helping with the negotiation process to help them brainstorm different ideas, help them hear the other person's perceptions, their feelings around that. So my role is not in any power dynamic. I am just there to help the negotiation process and to help them hopefully reach a resolution.
I know some people are worried about the confidentiality of mediation. And I know for most mediations, you send a confidentiality statement saying you're not going to share what happened in mediation to other people. You're not going to record it. You're not going to blog about it, things like that. So, but can you make a report? Are you required to make a report to the court about what went on in mediation, or in Utah, is that not something that is needed?
Yeah, in Utah, we don't. Well, there is. So there is what's called an ADR notice, or sorry, it's an ADR disposition notice. That is basically a paper that we as mediators, after the mediation is concluded, all it is we put the name of the case, we have the case number, we have the party's name on there, the date that we mediated, if attorneys were present on that mediation, and then we write, was there a resolution? What, like an agreement? Was there a partial agreement or a non-agreement? That's it. So we report that to the state, and that's just submitted to the state just for record keeping on that specific case, and also to show the judge, especially when mediation's been ordered, that we have accomplished mediation in at least a minimum of 2 hours. So that is it. I don't inform anything else that goes on. So during the mediation is completely confidential. So any negotiations that are happening in that, and I make sure that that is stated at the very beginning of mediation so people understand this is a confidential proceeding. The only ways that we as mediators would break the confidentiality, due to my code of ethics as a therapist, if there's any duty to harm, if a party says, I'm going to go harm myself or others, I would need to contact the proper authorities to make sure that their safety was involved there, as well as if a report of interpersonal violence or domestic violence, as it's known for, but it's interpersonal violence. Important to note that there's been a change on that. Child abuse, elderly abuse, or a computer crime. Anything like that that is like disclosed during mediation is not in confidence, and I would need to contact the proper authorities for that specifically. So the parties are aware prior to starting that there's a few reasons I would, but anything that is discussed in mediation is confidential until there is a drafted either stipulation, agreement, or a drafted divorce decree, stipulation to file, or a motion or anything like that, then everything is confidential until there's an agreement that's signed by both parties. And then therefore it's an agreement. It is not confidential, it's an agreement between them. So, and then the judge would see that as well.
Thank you so much for your time. Is there anything else you want to add about mediations or about your services?
Yeah, just again, when we're talking about like pro se litigants, because I will work with anyone who needs a mediator. I'm happy to assist either in pro se litigants or with attorneys. As being a Utah, and it's important that I just always like to inform people, make sure the mediator you're hiring is on the court roster for Utah, because we are certified and like court approved to do mediation. Attorneys cannot hire anyone that's not on the court roster. So just important to make sure when you're researching your mediator in the state of Utah that you go to utahcourts.gov, look up the mediator, making sure that they are on the court roster. And so that is important. There's so much training that goes into it. We've been observed mediating. There's a high quality of like, different quality assurance when it comes to the type of mediator that you're hiring. And so the only other thing I would say is when I'm working with pro se litigants, again, which is different than typically you do a mediation, you start and you go all day till you get your agreement settled that day. You're not leaving the room until you get a settlement. If you don't, then the next case would be either to reschedule a mediation or go to pretrial, start doing discovery, go to litigation. I do something different when I'm working with pro se litigants and they're representing themselves, which means when they're coming to me for like to settle their entire divorce case, It's what's called an uncontested divorce. And so they're not disagreeing with anything. And so I normally schedule mediations for 2-hour blocks. So we mediate for 2 hours due to the nature of the emotions in that, and that we're meeting together in one room. We do a 2-hour block. And then they go home. We have a few days in between. Then we do another 2-hour block of mediation. What that does is it gives parties time to think. They may have more research that they need to do because they're representing themselves. They may not know all the things they need to bring, even though I do provide them with an email that states, okay, we need mortgage statements, you need pay stubs. I give them all the things that they will need to bring to mediation. But sometimes they just need to think on something. I provide them time where we can break up the mediation, and so that they completely understand the agreement that they are entering into in order to finalize their divorce. So it's just a little bit unique and something that I offer that I have had excellent feedback from my clients that they like that it's broken up into different sessions, so they have time to really think. I try to get them done and resolved within a few weeks. If they want to spread it out, and I've had cases that have been 4 or 5 months where they're like, we're going at our own pace. And I'm like, that is absolutely fine. This is your agreement. You guys are in the driver's seat. I am here just to provide you with the dates that I can mediate.
Thank you so much. So if someone wants to get in contact with you, what's the best website and phone number to get in contact with you?
Yes. So my website is Sara Dickson MSC SC.com. So that's my website. You can also look me up on Google, Sara, SARA, and then DICKSON. And I'm in Lehi, Utah. That's where, and so you can look me up on Google. I'm here, and my phone number 801-243-4547. Text message is the best way to contact me, as in the majority of my day, I'm in session. So I'm either working with just clients all day long. And so text is the best way to reach me. And I also get back, and email is great as well, because I do respond to emails within 24 to 48 hours, as well as voicemails. So that's the best way to get a hold of me.
Well, thank you so much for your time and your knowledge.
Great. Thank you so much.